of the AIB All India Bar Examination Cohort 17 2023 virtual class. Yes, anyone can unmute and read what I posted on the screen. Hurry up.
Welcome to the Aspirants AIBE 17-2023 Virtual Class 12-01-2023 CRPC English with 10 a.m. to 11 p.m. Thursday, Professor Dr. Mohammed Saheb Hussain, sir.
Thank you very much. Yes, without wasting the time, let me shoot. Be ready for the first question. First question. Which statement is the false statement among the four as a CRPC? I said false statement. A. The main objective of this code is to provide a fair opportunity for an accused person to conduct a fair trial according to the principle of natural justice. B. The provisions of this code are to regulate the procedure for arrest and investigation, inquiry, and trial of an offense under any law governing criminal offenses in the court of law. C. The code contains 484 sections spreading along the 37 chapters along with the 2 schedules and 57 forms. D. CRPC does not supersede any particular law or any local law or powers or procedures directed by any such law. I said among the A, B, C, D, which is the false statement? Shoot.
D. D is correct answer, sir.
Read.
CRPC does not supersede any
WING.
local law or powers or
WRONG.
D is right answer, sir. CRPC does not supersede any particular law or
WRONG. Second option.
C is right answer, sir.
If C is the right answer, tell me why C is the right answer. Means right answer in the sense wrong answer. Why is a wrong answer? You have to give the reasoning.
2 schedules is a wrong answer, sir.
You have to give the reason why it is wrong. Okay, I will tell you. You cannot give the answer. The code contains 484 sections. It is true. Spreading 37 chapters. It is true. But the 2 schedules. It is true. But 57 forms wrong. It is the 56 forms. So see, the code contains the 484 sections spreading along the 37 chapters along with the 2 schedules and 56 forms, not 57 forms. Is it clear?
Yes, sir.
Good. That's what I want to expect from you. Second question. Popularly known as the Criminal Procedure Code, CRPC, within parentheses, it is the primary legislation regarding the procedural aspects of the criminal law. It also contains the certain provisions that are not strictly procedural in nature, which includes provisions pertaining to the prevention of nuisance, and maintenance of the wife and children. A. Section 130 and Section 124 to 128. B. Section 131 and Section 125 to 128. And C. Section 132 and Section 124 to 128. And D. Section 133 and Section 125 to 128. See here, you may wonder where is the another blank. Here is another blank.
C is correct.
Sir,
Section 132 and section
D is the
120
right answer, sir.
128.
D. No, D is the right answer, sir. Section 133 and section 125
Lara
to
ito,
128.
And section D is the right answer. It is section 133 and section 125 to 128 is the right answer for the second question. Nuisance comes in the 133 and 125 to 128 regarding the maintenance of the wife and children. Is it clear? Third question. The administration of India was taken over the rebellion of the 1857 by the British Crown, and subsequently the Criminal Procedure Code was enacted in the year 1861, which is the correct option. Number 1. The enactment of 1861 made the European communities immune from the jurisdiction of the criminal court except for the High Court. 2. The code was amended in the year 1872, 1882, 1898 to ensure the uniform application over the British and Indian subjects. 3. The legacy of the British India continued until the present code came into effect in the year 1973. So, 1, 2, 3 statements I have read regarding the above 38 question correction. So, now here A, option 1, B, option 1 plus 2, C, option 2 plus 3, D, option 1 plus 2 plus 3. Means,
Plus 2 is
Option
right.
1 plus 2.
D.
D
which
is right
one is the
answer.
correct answer?
1 plus 2
1
plus
plus
3.
2. No. 1 plus
Only
2.
1 plus 2 is correct, sir.
If it is give the answer, you have to tell the reason also. Why it is right and why other thing is wrong.
Because, sir, this C option is wrong because it is 1973. The legacy of British India continued until the present code came into effect in the year 1973.
So, which is your, according to your option, which is the correct option here?
1 plus 2.
1 plus 2
Wrong.
only, sir.
D is
It
right
is the
answer, sir.
2 plus 3 is the right answer. I will give the why. The enactment of 1861 made the European natives, not communities, European natives immune from the jurisdiction of the criminal courts except of the High Court. Means the first one is wrong. That means second and third is right answer. Is it clear?
Okay, sir.
Yes, sir.
See, I am making the questions you cannot expect. That means I am giving in the different angle the questions. So now fourth question. I will read it. Which option is the correct option? Number 1. Section 144 of the Criminal Procedure Code is frequently used to prohibit assemblies of 4 or more individuals or to order mobile phone companies to block voice, SMS or internet communication in one or more geographical areas. 2. No order passed under section 144 can retain the force for more than 2 months from the date of the order. 3. The state government can extend this but not more than 6 months. 4. The British rule used section 144 for the first time in 1861. Since then, it was used by the colonial government to suppress all the nationalist protests that has taken place in the struggle for independence. So the 4 options I read it. Now you have to shoot which one is the correct option. Here I have given options. A, 1 plus 2, B, 1 plus 2 plus 3, C, 2 plus 3 plus 4, D, 1 plus 2 plus 3 plus 4.
C. So 2 plus 3 plus 4 is right, sir.
WRONG. Shoot again the right option.
B is right answer, sir. 1 plus 2 plus 3.
If you say that D is the right answer, that is 1 plus 2 plus 3 plus 4, WRONG. I could not see the girls' town or ladies' town today. Sorry, it's too late. No, sir, we slept.
B is the right answer, sir. 1 plus 2 plus 3.
No. See, I made only little changes here. Number 1 is correct. Number 2 is correct. Number 3 is correct. Number 4, I made little changes. The British rule used section 144. That point, I actually did it. The British Raj used section 144 for the first time in 1861. It is not the rule, it is the British Raj. See, a minor changes I made it. I would like to see whether you can make it out or not. But anyway, I am training you in such a way, if a question is asked, without your knowledge, you can shoot it, even though you don't know the answer. Is it clear?
Yes, sir.
Yes. Read the 5th question in the sonorous voice.
According to section 2, subsection H.
It is not subsection, class H. Section 2, class H.
H of the code dash is process of collecting evidence by either a police officer or any other person that is authorized by a magistrate to do so. Option A, charge sheet. Option B, an inquiry. C, a study. Option D, an investigation.
Option D, investigation.
Repeat.
D, an investigation is right answer.
You are right. It is an investigation as per the section 2, class H of the Criminal Procedure Code. So, for the 5th question, right answer is D, an investigation. Now, anyone can unmute. Those who read, give the chance to other people. Loud voice.
The process of investigation starts by taking cognizance of a case and is completed when the police report is submitted under dash A, section 170, B, section 171, C, section 173, and D, section 173.
Actually, I have to make 174.
174, yeah, okay.
Which is the right answer?
Section 173 is right answer.
273.
73.
Option?
C.
Option C, section 173 is the right answer for the 6th question. Is it clear? Say yes.
Yes, sir.
Okay, now 7th question. I will read it because it's the lengthy one. Arrest means the apprehension of a person by the authorities, thus depriving him for his liberty. In criminal law, it is an essential aspect so that the accused is made to face the process of law and also prevents him from absconding. Some important rights that a person who is being arrested has are, now options are given. 1. Statements. There can be no legal arrest if there is no information or reasonable suspicion that a person has been involved in a cognizable offense or commits the offenses specified in the section 41. 2. Section 46 of the CRPC envisages modes of the arrest, that is, it has a submission to custody, touching the body physically, or confining the body. In case the force is required to make an arrest, it should not be any more than is actually required. 3. The arrest person must be informed. Please mute it. I am getting the sound. Please mute it. 3. The arrested person must be informed of the grounds of the arrest as soon as he is arrested by virtue of the judgment in D.K. Basu case and subsequent amendment in the CRPC. The arresting officer is to inform a friend, a relative, or a nominated person of the arrestee. 4. Section 54 of the CRPC provides for a compulsory medical examination of the accused by the medical practitioner. In the case of the males, the examiner has to be male too. Now the options are A. 1 plus 2, B. 1 plus 2 plus 3, C. 2 plus 3 plus 4, D. 2.
C is
Sir,
right
2
answer,
Plus
sir.
3 plus 4.
C is right answer. 2 plus 3 plus 4.
C is
Right.
right answer, sir. 2 plus 3 plus 4.
Wrong. Check it again. What is number 1? Is it correct regarding the arrest? 46, whether it is the correct. 3, whether it is the correct. And check the 4, whether it is the correct. Take another chance. Take another chance.
1 plus 2 plus 3.
1 plus 2 plus 3 is the right answer. The reason is, I will tell you the reason. If you happen to see the closely 4, Section 54 of the CRPC provides for a compulsory medical examination of the accused by a medical practitioner. In the case of, I removed the female, I made the males. I removed the female, I made the males. Case of females, the examiner has to be female only or female too. See the feedback. Section 54 of the CRPC provides for compulsory medical examination of the accused by a medical practitioner. In case of females, the examiner has to be female too. Is it clear?
Clear, sir.
If the male is there, what is wrong with the female will check it? Are you following me? Are you following me?
Sir.
Okay, now the 8th question. What is bail? Which one is the wrong option? I say wrong option. Please mute. See, somebody kept it open. I am getting the sound. Quinking, 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 quinking. When you speak, you can unmute. But when you don't speak, you can mute it. Okay. What is the bail? Which one is the wrong option? Number 1, regarding the bail. Bail means the temporary release of an accused. It is not only the essence of the criminal procedure, but also the bulwark of an individual liberty. 2. Under CRPC, the cases in which the accused is entitled to bail are referred to as bailable offences. On the other hand, non-bailable are those cases where the release on bail is to be decided by the competent court. 3. The accused can be released on bail in the cases by the court after imposing some conditions. Number 4. The code also provides for an anticipatory bail in case of any person is apprehending arrest. There is a bail even after the person is arrested. Among the 4, now we can shoot which is the wrong option. Here option which I have given is A. 1, B. 1 plus 2, C. 1 plus 2 plus 3, D. 4.
C is right answer.
4,
1
sir.
plus 2 plus 3.
Wrong is 4 answer.
Wrong is 4 answer. Because, tell me the reason.
Because, sir, the anticipatory is before actually. Anticipatory bail
It is before, not even after.
before that. Yeah.
Anticipatory bail is before. Bail even after the person is arrested, no. It is, here I have given, the code also provides for an anticipatory bail in case any person is apprehending arrest, that is bail even before the person is arrested. So now I am sure that you learn the technique now. Supplementary question. For the purpose of the trials, the cases under the CRPC can be classified into 4 categories. Can you tell me what are the 4 categories for the CRPC cases? Supplementary question. Sir, show me the option. If I show the option, even a small girl can also shoot it without knowing the law. What are the 4 summary trials? See, I gave the already answer. 4 often trials are cases: summon cases, warrant cases, summary trial cases, executive. What is another one?
Trial examination summary.
There are 4 major. One is summary, one is warrant cases, another is arrest cases, another is there are 4. Anyway, that please, I did not ask because that is the easy thing. Okay, 9th question. When something is stolen, then according to dash of IPC, FIR is filed. When something is lost, then dash is filed. A. Section 378 and NCR. B. Section 379 and NRC. C. Section 378 and NRC. D. Section 379 and NCR. Sir, first tell me what is NCR, sir?
C is right answer. Section 738, 378 and NRC.
WRONG. Tell me what is NRC? What is NRC? Say pass on.
Pass on, sir.
NRC means non-recorded cognizance. We cannot, if it is a cognizable offense, FIR will be filed. If it is a non-cognizable offense, FIR will not be there. Hence, they told me once when I lost my phone, sir, I told them my phone was stolen. He say, if stolen would be there, I have to write the FIR.
B
And
is
you are
right answer, sir.
And you are
B is
not
right
supposed to
answer.
say stolen. You say you lost. So that is NRC will be issued. And then later on you can show to anybody else that you lost your phone. This is enough for the police record. Is it clear? The right answer is
B.
D is right answer. Sir.
D is the right answer. 379 and NCR. So he told me don't write stolen, you write lost. So I wrote lost in the police station. Okay, 10th question. Which one is the odd man out? It means which one is the false among the 4? Here 4 I am reading. A. It stipulates a minimum jail for term of 20 years which may go to up to life in prison or death sentence for the rape of a girl under the 12 years, while perpetrators, a person who carries out a harmful, illegal or immoral act within parentheses involved in the gang rape of the girl below the 12 years of age will get life imprisonment or death. A statement. B. Amendment was made to subsection 1 of the section 376 of the CRPC, increasing the term of punishment of perpetrator from 7 years to 10 years. C. The amendment under section 376 of the CRPC additionally makes a provision for the fine to be payable to the victim. D. Section 439 of the CRPC was amended to make it imperative for the courts in cases of the grant of a bail to an accused under section 376 subsection 3, section 376AB, section 376DA, section 376DB, capital DB, for the IPC to give the notice of the application to the bail to the GP. So now A, B, C, D, and among them, which one is the false among the 4? One is false among the 4. What is that? Okay, I will give you the
D is false.
I know that D is false. Tell me why it is false. I know that you can shoot it very nicely. I don't no doubt at all. But give the reason. In the criminal procedure code, there is a government pleader is there. PP is there.
Yes, sir. PP is there.
But why you are not giving the answer? See, I take government pleader. Whether the government pleader is there in the criminal cases. In the civil cases, government pleader is there. In the criminal cases, PP is there. You have to give the answer. PP, sir, is not the GP. Is it clear?
Correct, sir.
Yes, sir.
See, that is the IQ of a person. Okay, 11th question. The Code of Criminal Procedure 1973 came into effect from the April 1st, 1974. The purpose of the code is to provide the machinery for prosecution, trial, and punishment to offenders under the substantive criminal law, that is dash. A. Law of contract. B. Civil Procedure Code. C. Criminal Procedure Code. D. Indian Penal Code.
Indian
D
Penal
is
Code.
the Indian Penal Code.
It is
Penal
very
Code.
easy to make it out. I say substantial law. Then law of contract is a not a of course substantial law, but it is a civil law. Am I right?
Yes, sir.
Right, sir.
So the right answer is
Indian Penal Code.
Indian
The
Penal
answer.
Code is the right answer. Yes, anyone can unmute and read 12th question. Please, those who read, give the chance to other people. I would like to see their accent. I would like to see how they read. Hurry up.
Provides an opportunity to the accused person to get a fair trial by considering the principles of dash. A. Economic justice. B. Social justice. C. Financial justice. D. Natural justice. D.
D
Natural
is
justice.
the answer, sir. Natural justice.
It is the natural justice, not economic justice, not social justice, not financial justice. It is I fabricated it. So 13th question. Match the following section from part A and suitable title from part B. Part A, section 300, section 304, section 307, section 311. Part B, legal aid to the accused as a state expenses in certain cases. B, excuse me, person once convicted or acquitted not to try it for same offense. C, power to summon material witnesses or examine the person present. D, power to direct tender of pardon. Here options I have given. A, 1B, 2A, 3D, 4C. B, 1A, 2C, 3B, 4D. C, 1C, 2B, 3A, 4D. D, 1D, 2A, 3B, 4C.
Option A, 1B, 2A, 3D, and 4C.
You are right. Option A is the right answer. See here feedback I have given. Section 300, a person once convicted or acquitted not to be tried for the same offense. Section 304, B, legal aid to the accused of estate expenses in certain cases. And Section 307, power to direct tender of pardons. Section 311, power to summon material witnesses or examine the persons present. Now 14th question. Anyone can unmute and read? Hurry up.
14th question. IPC within parenthesis Indian Penal Code and CRPC Criminal Procedure Code were introduced in the year of 1861. These laws were codified by a Thomas Babington Macaulay, who was a
Macaulay.
Is it
Thomas Babington Macaulay.
Macaulay,
Who was here?
who was a law member according to the Charter Act of Dash. These laws were introduced by Dash within parenthesis 1856, 1861. Option A, 1832 and Lord Diplock. B, 1832 and Lord Lithgow.
Lillington.
1830 Lithgow.
Okay.
C is 1832 and Lord Atkins. D is 1833 and Lord Canning.
Sir, B, 1833 and Lord Lilinthingo.
WRONG.
C is right answer, sir.
Read.
1832 and Lord Atkins.
WRONG.
D is right answer, sir. 1833 and Lord Canning.
It is D is the right answer. It is 1833, Charter Act of 1833, and these two acts are introduced by Lord Canning. But they are made by the Thomas Babington Macaulay. 15th question. According to Dash, there are 4 kinds of criminal courts: Court of Sessions, Court of Judicial Magistrate, Court of Metropolitan Magistrate, and Executive Magistrate. Now, option A, which section says? Section 4, option B, section 5, option C, section 6, option D, section 7.
Section 6. That is C option.
Option C is the right answer. It is a section 6 says about the types of the courts. Now 16th question. As provided in the section 212 of the CRPC, the charge must contain the details of the dash alleged to have been committed. Which option is the exact or correct sequence? A, place and time of alleged offense and the name of the person against whom or the thing against which or such offense has been. Sequence. B, time and place of the alleged offense and the person name against whom or the thing against which such offense has been. C, time and place of the alleged offense and the time of the person against whom or the thing against which or some of has been. So now I made A, B, C, D. So now you can shoot what is the right sequence of writing regarding the charge is concerned.
Section B, time, place, and person. Option B, time, place, and person.
Check closely. Almost all the same thing I made, or did I change? There is a change is there in each and every one. So the correct charge, charge must contain in the option D, the last one, time and place of the alleged offense and the name of a person against whom or the thing against which such offense has been is the right answer. But when you see the first one, place and time, actually it is the time and place. Is it clear?
Yes, sir.
That means A is eliminated. Okay. Now B. Tell me what is the B. We can eliminate it. If you closely watch it, time and the place of the alleged offense, okay, correct. And the person name, not the name of the person. Is it clear?
Yes, sir.
That means B is deleted, eliminated. Now check the C. In check what is the wrong there. Time and place of alleged offense and the name of a person against whom are a think. It is not a think, it is a thing. That means C also eliminated. When the C also eliminated, A also eliminated, B also eliminated, what is the right?
D answer.
D is the answer. Excuse me. 7th question. In a criminal trial, the purpose of examining the accused person under dash CRPC is to meet the requirement of the principle of natural justice, that is, adi alteram partem.
Section
Now,
311.
let me read first, then you can shoot. A.
Section 311.
Section 311. B. Section 312. C. Section 313. D. Section 314. Now you shoot.
Option A is the right answer, sir. Section 311.
WRONG.
312, sir. 312 is right answer.
WRONG.
D is right answer, sir. Section 314.
WRONG.
C is right answer. Section 313.
The right answer is Section 313. It is the right answer for the natural justice, that is Adi Altram pattern. So 18th question. Dash CRPC elucidate that any information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced in writing by himself or under his direction, and all such information, whether in writing or reduced to writing as aforesaid, shall be signed by the person who furnishes it. Options: A. Section 154 Class 1, B. Section 154 subsection 2, or Section C 154 3, D. Section 154 subsection 4.
Sir, what is the difference? Class
154 of
A,
2, sir.
subsection 2.
154 of 2.
See, I fabricated some of the sections. The right answer is Section 154 1. A is the right answer. Is it clear?
Yes, sir.
Other I fabricated. If it is there or not, doesn't matter. 19th question. Dash CRPC explains that the complaint shall be given in writing or by post to the superintendent of police if any person is aggrieved by the refusal on the part of the officer in charge of the police station to record the information referred to in subsection A. Section 152 3, B. Section 153 3, Section C 154 3, Section 155 3.
Section D.
Answer is Section 154 3 is the right answer. That means C is the right answer. A, B, C. C is the right answer. 154 and subsection 3 of the CRPC explicitly says about the above statement. Anyone can unmute and read the 20th question?
Section 156, subsection 3
Entails
entails that any magistrate empowered under section 190 may order on investigation by a police officer performing its duties under chapter dash of CRPC. Option A, X. Option A, 10th. Option B, 11th. Option C, 12th. Option D, 13th.
Option D, 13th.
wrong. Second option.
Option D is the right answer, sir. 11.
It is the C is the right answer. 12 is the right answer. I repeat, 20th question, section 156, subsection 2, 3 deals, and the ending is option C, Roman 12, capital or uppercase Roman 12. The right answer. 21st question. If despite approaching the superintendent of police or the officer referred in the section 36, his grievances still persist, then he can approach a magistrate under section 156, subsection 3 of the CRPC instead of rushing to the High Court by way of writ petition or petition under dash. Section 480 of CRPC, B. Section 481 of the CRPC, C. 482 of the CRPC, option D. 483 of the CRPC. You need not to go to the High Court. for every writ.
Sir, 481 of CRPC is right answer.
WRONG.
483, sir.
WRONG.
482 is right.
482 is the right answer. You need not to go every time the Article 226 to the High Court, Article 32 to the Supreme Court. Okay, 22nd question. Under a schedule, that is the first schedule, the following chapter deals with the following in which are given in Part A and Part B. I say schedule. Which schedule? First schedule of CRPC. Okay. Number 1, Chapter 4, Chapter is it 9, Chapter 11, Chapter 15. In the Part B, offences related to religion, false evidence and offences against the public justice. Then C, offences are relating to the public servant. D, offences against the state. Options are given like this. A, 1C, 2B, 3D, 4A. B, 1B, 2D, 3A, 4C. C, 1D, 2C, 3B, 4A. D, 1A, 2C, 3B, 4D. Here options. In the schedule, there are chapters. From the schedule, I picked out. Yes, did you check it? Can you see the screen? Participants,
Yes, sir. Yes, sir.
your silent will kill me.
Yes, sir.
Give the answer, even though wrong doesn't matter.
B is right answer, sir. 1B, 2D, 3A, 4C. Sir.
The right answer is C. 1D, 2C, 3B, 4A. Here I have given the feedback. Chapter 4, offences against the state. Chapter 9, offences are by relating to the public servant. Chapter 11, A says mute, Ramesh Babu. Chapter 11, false evidence and offense against the public notice. Chapter 15, offences relating to the religion. So 23rd question. Anyone can unmute and read? Unmute and read. 23rd question.
Legislated as a tool for dash section 125 of Criminal Procedure Code 1973 provides an effective remedy for neglected persons to seek maintenance. A follower of any dash can apply for maintenance under section 125 without restriction.
Option A.
Option B is right answer. Social justice and religion.
You read the options.
A. Social engineering and religion. B. Social justice and faith. C. Social tool and belief. 4. Social justice and religion.
Not 4. Option D. Social justice and religion. So there are A, B, C, D. Now you shoot.
Social justice and religion is right answer, sir.
If the right answer is social justice and religion is the right answer, that means D is the right answer. 24th question. Chapter 10, maintenance of the public order and tranquility. And here A, B, C, D in Part A and Part B, public nuisance, unlawful assembly, dispute as to the movable property, urgent cases of nuisance or apprehended dangers. So here made the options A, 1B, 2A, 3D, 4C, B, 1A, 2C, 3D, 4C, and C, 1D, 2B, 3A, 4C, D, 1C, 2D, 3B, 4A. So these are the chapter 10, maintenance of the public order and tranquility. So A, B, C, D divisions are there, and here I made the explanation. Though match the following, then which option is the right option?
Option A.
Option A is the right answer. That is 1B, 2A, 3D, 4C is the right answer. Because Chapter 10, maintenance of the public order and tranquility. A, unlawful assembly. B, public nuisance. C, urgent case of the nuisance or apprehended danger. D, dispute as to the immovable property. Then 25th question. Anyone can unmute and read.
The second schedule is based on section A 472, B 474, C 475, and D 476. The second schedule 474 is section 474 is the right answer, sir.
WRONG.
476.
That is the right answer. See, here I have given the 484 and it is the first schedule. I did not frame the question what the first schedule says. First schedule says about?
1 to 5th.
I say first schedule says about? It is there on the screen.
Classification of offences.
It is there on the screen. Excuse me. And if you turn to the second schedule, it says about form 50, 52, 56 are there total. Then second schedule start 55, 56. Yes, second schedule starts here. Where it's gone? Appendix. This is second schedule. It says of the 486 section. This is appendix. This is. So today I framed those questions based on my own caliber, using my own intelligentsia, not the repeating the same which I taught in the last 15th cohort and 16th cohort. I taught 2 times. You will have at least 2 to my YouTube online classes. But I did not pick out those. I made a new one so that you could have a different angle to shoot it. And tomorrow also I will base my most lecture on cases, the landmark cases in the CRPC, and we'll deal on it. And I don't know whether this time is convenient or not, because I could not see the many participants here. Now that today's participants are, if I not be mistaken, it is 8. They are not reduced. Is A. Venkat Reddy, today he is enrolled. I have say congratulations to be enrolled as an advocate. And in Kiswahili, I can say that is a Karibu Sana, and you are welcome. And Ongera Sana, and congratulations. Asrini is there, Gurrapati Suresh is there, Manzoor Khan is there, Ramesh Babu is there, Shailaja K is there, Sri Lakshmi is there, and these are the people, including me, 8. So, because of I do have my classes here in the masters, can I switch or make all the classes from 9-10? What is your opinion?
Yeah, that's the right time, sir. 9 to 10 is right time.
9-10 to 10 o'clock, I will make all the classes, because I can switch over my own schedule here, and because I found many people are missing. So it is a blanket. I will make it tomorrow. Any class of mine is 9-10 to 10 from tomorrow onwards.
Okay, thank you, sir.
Okay, thank you.
Because I noticed 10-10, you could not make it out, because 10-10 to 11 means, of course, for me it is only 8:30. For me it is 8:30, but for you it is 11 o'clock. And hence, I will also post, and please try to inform the other people also. Of course, today they will watch my YouTube. From tomorrow onwards, till the end of my online classes, the classes commence from 9:10 to 10 o'clock India time.
Okay,
And of course, today is the Vivekananda Day. I don't know, because otherwise I would have to keep one webinar on the Vivekananda Day. but I'm staying in the foreign country. That's why I could not know whose birthday is falling or. Otherwise, I would have to make a webinar. But a webinar, I'm going to conduct it on the 15th, that is Sunday. The India time is 6 o'clock. I will post it today. It is a Martin Luther King Jr. I don't know whether you heard it or not. It is the 15th January, it is his birthday, and he is a civil law movement. He is I believe he is a lawyer also, because he fought for the blacks, for the equal justice in the United States of America. So I am conducting a webinar. If you want to participate, you can participate. If the time left over there, I can give the chance also to speak you regarding that webinar is concerned. Yes, are you hearing me?
Yes, sir.
Yes, sir.
And still some time is there. I don't know today. Cisco WebEx is not closing down. Of course, I did not get even the 5 minutes caution also. I believe that I finished it early. Is it true?
True, sir.
Okay. So with this, I will post it also. That is Dr. Martin King Luther Jr. The webinar on 15th, India time 6 p.m. So that, of course, I invited the many countries people like Uganda, Kenya, and Nigeria, United States of America, and some of the people from India also. And they will speak regarding what is the contribution would be there. So tomorrow class is solely based on cases. Yes, now it is that the meeting will end for all the participants in the 5 minutes. The indication has come over here now. The meeting ends. So with this, I would like to wind up my today class, and let we meet tomorrow at 9:10. Please inform all the people, and the flat level it is changed from 10:10. It becomes too much late to you. So all the classes from 9:10. With this, I will stop my today's class, and I would like to say Jai Hind.
Thank you, sir. Good night, sir.
Good night.
सारे जहां से अच्छा हिंदुस्तां हमारा। जय हिंद।
जय हिंद।